Welcome everyone to the very last session of this module, Legal Implications of Climate Change. So today's session, we're going to go and look at a couple of case law. So this has a twofold purpose. One is to, of course, introduce you a little bit more in depth to climate litigation. And the second reason is it will help you in your final assignment as well. How to approach the case law, how to pick and analyze, but more importantly, how to link it back into the Paris Agreement and the goals that we have studied as part of the Paris Agreement, right? So let's get on straight into it. So let me share my screen. There we are. Okay. So, like I mentioned, we are back into global climate litigation. A bit of a recap. In a previous lecture, I suggested that the climate litigation is increasing, and we looked at the case law as they are spread around the world. More than half of it is in the US. It's a bit understandable given the amount of litigation in general is much higher in the US. But then we also saw that there was a good spread of case law related to legislative provisions that impact on climate goals. So they could relate to reduction of greenhouse gas emissions. They could relate to lack of adaptation plans or lack of good adaptation plans. They could also relate to other parts of economic activity that then have an impact on climate, like trade, investment, etc. And there was also another set of case law, which is quite a large number and across the globe on the same theme, which is around human rights law. So questioning the extent to which states are not properly protecting the right to life, the right to health, and also even creating new human rights like the right to a healthy environment. So quite a wide spread of legal principles called into question in the context of addressing climate change. So that's the background. What I've decided to do today is consider one case which is investment related and consider a second case which is human rights related. And then finally, a brief note on the role of lawyers in climate change litigation. So let's go into it. Let's start by looking at the first case. Okay, the first case takes us to South America and to Colombia. This case is the Eco Oro Minerals Corporation versus the Republic of Colombia. This is an arbitration case, and it came up before the Center for Settlement of Investment Disputes. So I've given you a link to the Sabine Climate Change Center, which maintains the climate change case law chart. It's a good site where it has categorized different case law according to the causes of action. So some of the pages also have a complete record or links to the complete records of the cases. So I've given you that link here. And it's this particular decision is, as you can expect, those of you who are studying investment law will be familiar with it. Those of you who are not studying investment law, the judgment is rather bulky, running up to around 500 pages. So You will come across such case law when you look through what to choose for your final assignment. I'd ask you not to shirk away if the judgment is quite long. Those are the kind of judgments that will give you really good substance for analysis and to develop your understanding of where the future rules are going and how the current rules are being interpreted. So hopefully, looking at one of the bulkiest cases today will help you navigate these when you get to it yourself. The picture you see over there is the place or the site which is being disputed over. Okay, it's a large area in the mountainous region in the Andes Mountains, which spans across different countries in the northwest of South America. And Colombia is one of the countries where this particular special ecosystem is found. So this picture there is this ecosystem. It's not too high, it's not the highest, it's not too low, it's somewhere between, let's say, a tree line, a high tree line mark on a mountain, above that, but below the sort of snow-capped regions of mountains. So it's one of those, it is high altitude, but it's pretty life-sustaining from that perspective. So you can, the picture over here shows you water bodies. One of the significance of this region is also that it supplies water to many of the main cities in Colombia. The same is done by these regions in the other countries where this type of mountain terrain is found. So they are quite important for their ecosystem services, so provision of water for the populations, but they're also important for the biodiversity that they hold. And they have special type of vegetation which are able to lock carbon within them, right? So they act as carbon sinks. This obviously has now become quite special given that we need to address climate change, and one of the key ways of mitigation is to make sure that carbon sinks are actually preserved and carbon sinks are not dug up, carbon sinks are not destroyed, in which case what they do is they release the carbon. They become sources of carbon. So that shouldn't really happen. So from the climate change perspective, this particular landscape and this environment takes on new importance. Okay, so the big picture issues as far as this case is concerned. It really is an illustration of the struggle between competing societal objectives which pull in opposite directions. These are the two directions. On the one hand, is the protection of the treaty rights of an international investor. On the other hand, the ability of a community to take legitimate measures to conserve its environment, and in this case, because of its special importance as a carbon sink. To break that down a little bit more, these are the different competing interests. First is the protection of the environment. Second, the need for water in the surrounding areas. So that could be framed as the right to water and therefore the state's duty to fulfill the right to water of its people. Then the livelihood of local farmers as well as artisanal miners. So the place is rich in mineral resources. So the people inhabiting this area either rely on farming or they rely on their own sort of homemade mining. Artisanal mining is basically mining of materials in very small quantities on a sort of a cottage industry basis. Protection of jobs provided by foreign mining companies. So alongside the artisanal miners, you also have the big mining companies. And mining is, again, a worldwide industry. So often they would be transnational corporations, meaning they may not necessarily be Colombian registered. They'll be foreign mining companies. So foreign mining companies will bring investment, which means it brings jobs as well. So that's definitely an interest in the area's resources. And then the rights of these mining companies. Yeah. So foreign mining companies don't just come in to a country. They are regulated through regulations beyond contractual obligations as well. They get, first of all, the right to mine, and then they have to go through and comply with a number of different regulations in the host countries. So these regulations give rise to rights for these mining companies. So that's these are all the different competing interests that we are going to be looking at in the context of this case, but it's also typical of similar situations in other parts of the world as well. Here, I'll recall last lecture where we talked about the critical and strategic raw materials required. And one of the conclusions from that session was that there was going to be increased mining around the world for the different critical raw materials. In this case, it is not a case of critical raw materials. In fact, this case is all around precious metals, gold and silver. Okay, so the mine itself is not producing any material that is relevant to the, or necessary in any big scale to the energy transition or digital transition. So it's not the substance of the mining that is linked. However, this is an issue of the protection of a carbon sink versus the mining operations, which will certainly have an impact on the carbon sink itself. Something to additionally note is the existence of illegal mining with inevitable harmful impact on special environments in the region. Some of this illegal mining might also be the artisanal miners, but others might not be the artisanal miners themselves. They might be operating on a larger scale, but without permits, without licenses. So either way, mining does have an impact. So mining is about scraping off the biodiversity of that region. If it's an open pit mining, it's going to be leaving bare scars. So that's pretty visible. If it's underground mining, again, at the same time, it destabilizes the environment as well. So this is another fact to contend with, although in this case, we are not necessarily in contention or looking at illegal mining. However, it did occur or was mentioned in the case as a sign of weak governance by the government. Okay, so the big picture issue, essentially, you've got the rights of investors, international investors, and then the protection of the local environment. Nothing so unfamiliar over here, I'd say. Let's look at the facts of this particular case. In 1994, the Eco-Oro Minerals Corporation, we'll call it Eco-Oro from now on, is a Canadian mining company, obtained a mining permit for Colombia's Angostura gold and silver deposits. So the geological surveys showed the presence of gold and silver deposits in this particular region of the Andes Mountains. And in 1994, quite early on, obtained a mining permit. 2007, this became a contract known as the Concession 3452, which was obtained by the Colombian Geological Survey, or the Colombian Geology and Mining Institute, as it was called then, in Geominas in 2007. Later on, it changed its name. So it's a solid concession, a contract for mining, for exploring, for exploiting, as well as for exporting. In the same year, in 2007, Colombia also passed its general environmental law. And in the general environmental law, it spoke about different protected areas. So this particular area is known as the Santurban Paramo. Paramo is the name given for the whole of that region with that very special sort of a landscape. In the slides that follow this slide, I've put some pictures there to give you an idea of what this landscape actually looks like. So Paramo is that wide region, and within the Paramo, it's like saying grasslands, or it's like saying the steppe. Okay, so that's what a Paramo is. It's this special type of landscape in South America. And within that, there are different types of landscapes based on the height, based on the vegetation, based on the fauna. And this particular region in question, where Eco Oro got its concession, is in the region specifically known as the Santurban Paramo. Okay, so in the same year, this area was identified. So Santurban Paramo was identified as protected under the General Environmental Law of Colombia. And of the concession area, more than half of the concession area happened to fall within this particular protected classification. In 2008, there was a FTA signed between Canada, so the country where EcoCorp is registered, and Colombia. 2009, Eco Oro is wanting to start work in this area, so they submit various documents that are necessary for them to start the mine. So construction and work plan, known as PTO, and this was for an open pit mine. The sort of mines that you'd see if you're on an aeroplane, you'd see like, big machines, heavy machinery moving around, and you will see like no trees, big vast ochre areas being corroded and broken down and taken away. So it's that sort of picture, open pit mining. So that was the PTO was proposing such a mine. And they need an environmental license. So under the general environmental law, amount of waste they can create, how they need to treat this waste, what are the levels of pollutants that can be allowed in the atmosphere, what sort of impact that they might have on the water, what levels of maybe some acceptable chemicals that can go in. So all of this is the environmental permitting regime. They needed permits. So along with the construction works plan, they also applied for this environmental license. And along with that, you have to submit the EIA, the environmental impact study or environmental impact assessment. There's various different terms for this. But in general, they'll have to show. So these are all basic requirements nowadays for big operations that will have impact on human and environmental health. So Eco Oro then initiated all of this. In 2010, you get another law which specifically prohibited mining operations in the Paramo ecosystems. And the reason being the significance of the Paramo systems for various things. So it plays a central role in maintaining biodiversity. and it's also has this unique capacity to absorb and store water. So on these grounds, this particular law prohibited mining operations. Now, at the same time, you have these Colombian authorities, which is the mining department of the government. They order, because of this new law, they want the company to present a new environmental impact assessment. So they need to show, or they need to demonstrate that their activities will not affect the Paramo ecosystems. Okay, so this was the order that was put in 2010. So the 2008 Free Trade Agreement between Canada and Republic of Colombia enters into force from 2011 onwards. Now, these are some facts that are important to note in the context of the arguments that were presented before the arbitration tribunal in terms of admissibility of claims. What Colombia argued was the right that arose for Ecoora as an investor, as a foreign investor in Colombia, did not really arise until the entry into force of the FTA. Okay, so they laid forth some of those arguments to say that these claims are not really admissible under the FTA of 2008. But those were not, they were considered, but they were not accepted, and therefore the case was actually decided on merits. So the fact about the FTA coming into force in 2011 is just relevant for that issue. However, when I discuss later on, I won't be going into all the issues because they're not really required for our main purpose, to see how this climate litigation is going to further the aims of Paris Agreement. So I'm only selecting some issues, especially the ones on merits, which are relevant to climate change goals achievement. So I won't be mentioning this any further, but for those of you interested, very much, have a look at the full judgment and look at the preliminary objections raised as well. More pictures on the side here, showing you some stunning landscapes there. We've got a part of a mountain with snow capped and what looks like a really healthy and big llama, and then some very interesting sunflower type yellow flowers there. And then a map below showing you the spread of the paramos, the different area of paramo spread in the mountain regions. So you have some parts in Venezuela, you've got a stretch in Colombia, you've got quite a concentration in Ecuador as well. All right, so in 2011, given that the new law was passed in 2010, Ecoora now has to revise its works plan and its construction plan. They withdraw their environmental license application for that open pit project because they would not be able to reconcile protection of the Paramo landscape with their plan for mining. So now they put in a new request saying, are you acceptable for us to prepare a new construction and works program for an underground mine as an alternative? So they engage with the mines department. As you can see, there's quite a few, there's the tension that's developing between the mining department's priority and the environmental department's priority. Both are, wings of the Colombian government. So amidst all of this, the Ecoora is waiting and watching to see which will perhaps trump, so that they are able to produce a works plan that will be accepted, not rejected. So then they ask for extension of this, time to see where things go, and the mining department also grants an extension. And in fact, the mining department is very pleased with how this engagement is going, because there is a sensitivity that is shown for the environmental laws, and as they even come along, and the mining operation. So they even designate Eco-Oro's project as one of national interest. On the one hand, this could be them trying to say, well, it is something that's going to provide jobs, it's something that is going to bring economic development, and therefore it is a project of national interest, right? So you could, depending on whether you're a cynic or whether you are someone who believes that government departments do work by talking to each other, look at it as a national interest project because they wanted to make sure that the project gets enough of a publicity, so then it would be very difficult to reject it, or whether they really did think that they were doing all the right things. And at this point, the Environment Department still had not gone onto the ground and delineated or drawn the boundaries around the different types of Paramo ecosystem. So the Saturburn Paramo ecosystem, although it was there and recognized for its importance, the actual boundaries was yet to be delineated. More lovely pictures from different seasons in that area. So in 2013, Eco-Oro requested a suspension of its obligation under the concession, including its obligation to submit the works and construction program, because the Paramo delimitation was taking quite a long time, right? Because once the mining concession is granted, then the company itself has obligations to complete it within a certain period of time. So they didn't want to be held as a truant of this particular obligation. So they requested that any obligation on their part be stopped at this point or paused. So this suspension was actually granted by the Mines Department. And then in 2014, you have the Environment Ministry publishing the boundaries of Saturburn Paramo. So this was the resolution 2090. Now this indicated there was even a bit more area added. So there was a 54.7 overlap with Eco-Oro's concession area and the Saturburn Paramo designation. What's interesting though is this resolution provided exceptions to the general prohibition against mining in such areas. So to get it clear, under the 2010 Act, mining in the Paramo ecosystem was prohibited. So there was a general prohibition. But under Resolution 2090, there were exceptions that were provided for this general prohibition. Yeah. So that means Eco-Oro could potentially fall within this exception. 2016, these exceptions were struck down by judgment of the Colombian Constitutional Court. So now that window of opportunity that was present in the Environmental Act was closed, because the exceptions against mining or allowing mining in that area was now struck down. So that means the general prohibition against mining in the areas were now completely upheld with no exceptions. So now you can see this does impact the investment that Eco-Oro has made since about 2007-8 in that area. And this then leads to the request for arbitration in 2016. So what we are looking at today is that arbitration case. There were other developments that took place after that as well. So in 2017, the Colombian Constitutional Court struck down the whole of Resolution 2090. Why? It cited the lack of public consultations. So procedural justice was not met in this case. So the obligation to take into account a participatory process for identifying how that area should be protected was not followed. So the Colombian Constitutional Court struck it down, struck the whole of Resolution 2090 down. So where does that leave us? It takes us back to the period when there was an obligation to determine which area is exactly the Saint-Tropez area, but then that delineation has also been struck down now. So we're back to the position where the delimitation of this type of paramour landscape was again open because it was reversed. And even by the time the decision of this arbitration case came about, the exact area that can be considered the Saint-Tropez paramour was not finalized. Okay, so that is the brief background with some of the key material facts that are relevant to our discussion of the outcome. So now let's look at what was actually the case. There's a few more facts. 2018, the mining company, they confirmed the decision to reject further suspensions requested. They further directed the company. So the mining company was carrying on with the process of submission, extension, etc. Now they were forcing EcoOro to submit, because otherwise, under their regulation, if they didn't submit the plan of works, then they could be fined. So the mining corporation was still pursuing the operation, at which point EcoOro now filed for the renunciation of the concession. So they were giving up the mining concession that they received way back in 2007. So what was the cause of action? What was being questioned? Essentially, the lawfulness of the approach that was taken by the government of Colombia. On the one hand, to protect the Saint-Tropez paramour. On the other hand, the rights granted to EcoOro under the 2008 Free Trade Agreement between Canada and Colombia. So the disputing parties in this arbitration is not directly Canada. So Canada is a non-disputing party, but because it's a state party to the treaty, Canada also submitted its interventions in the case. So we're looking at what is the lawfulness of the approach. Yeah. So the obligations of Colombia and Canada under the 2008 FTA, have they been established? Have they been breached, etc.? So what are the particular provisions in the FTA? Now this FTA, these are more the new types of FTA. So the new FTAs essentially did take into account environmental protection. So the 2008 Canada-Colombia FTA included measures to ensure the protection of environment both in Canada and Colombia, and that these are not undermined by any rights that are granted to foreign investors. And that is enshrined in the FTA in 3 areas. So they say that the rights of the foreign investors in their respective countries are subject to any applicable law. So that will include the new laws that came protecting the paramour ecosystem. Then the policing powers that go with these laws to enforce the laws, etc. And then any exceptions that are agreed upon. Okay. So there is already scope within the FTA. It is a progressive free trade agreement that heeds both the country's environments. I mean, Colombia has quite a bit of mining, but so does Canada as well. Canada also has a lot of mining. So, and hence you can see the multinational corporations based in Canada also expanding their operations into other countries. So it's only right that both countries then do think of the environment. Their own domestic laws in terms of environment protection are also some of the most advanced in the world and in their regions. So what was the judgment in this case? So there were two key parts to the judgment. The first part, tribunal concluded that it has jurisdiction over the claims, so that's the admissibility done with. And as far as merits are concerned, a majority, so not all of the 3 arbitration panel members agreed to it. So 2 of the 3 panel members agreed to this decision. So by a majority, the indirect expropriation claim that was submitted by EcoOro under Article 811 of the FTA is dismissed. It's dismissed because of the provisions of Annex 811 2B, which talked about police powers. Okay, so police powers to enforce the legislation or the applicable law. So for EcoOro on this count, what they claimed was that Colombia made it impossible for it to carry on with the mining concession, and such that they were put in a position where they had to renounce their mining rights in the Agunos Sutra area for gold and silver mining. So that amounted to indirect expropriation. So expropriation is taking away the property, yeah, of that particular individual. In this case, it's a company. So it's not direct expropriation, but indirect expropriation. So for those of you who do investment law, these are fundamental principles. You know, investment is not going to be protected if the host country is allowed to expropriate or take that investment away. So fundamental principles. And therefore, EcoOro and Canada, on behalf of EcoOro, put this claim forward by saying that the mining concession now is not viable. Therefore, indirectly, Colombia has expropriated the property. But this was dismissed, saying, well, when the FTA itself provides for such laws, and therefore you are to expect that this might happen. Well, you know, a little bit later, we'll look at the concept of a prudent investor and see whether EcoOro has been a prudent investor. Should they have actually been expecting this sort of law to come, you know? So essentially, they basically said there was no breach of Article 811 because the regulatory measures for protection of the Saturban Paramo was a legitimate public welfare objective, and it was adopted in good faith. So the various criteria required to fulfill Article 11 or to show breach, they were all not really present. So the tribunal basically decided in favor of the Republic of Colombia when it came to indirect expropriation, that they did not. And we're not going to consider this further or the reasoning behind this, okay? Apart from to say that this is a progressive part of the judgment for the goals of the Paris Agreement, yeah? So we do need more mining, but we also need to make sure that the mining does not come at the expense of taking away a carbon sink. So from that perspective, this part of the decision is certainly beneficial and in the right direction. But there's another part to the decision. And this time, it's a different set of two members of the tribunal who decided this. So a different majority of the tribunal concluded that the claim brought by EcoOro in respect of Article 805 of the FTA should succeed. So 811 and 805 of the FTA were in contention. 811, the mining company lost, but 805, the mining company succeeded. So this is the one that we're going to focus on in detail. And then finally ask the question, does it actually help? The way 805 was decided, does it actually help our achievement of Paris goals? Or in some way, because 805 was decided the way it was, the benefit of deciding 811 the way it was has been taken away. So what is the level of maturity of climate litigation if the end result comes out a certain way, which we'll see in the end what it was. So the tribunal found that that Colombia was in breach of 805. Why? One of the reasons, the government's delay in delimiting the Santaban Paramo. They took time. Its failure to comply with its own constitutional obligations to protect the ecosystem at the time of the company's investment. So right from 1994, they would have been aware, okay? And they had obligations under their own constitution. Hence, the Constitutional Court struck down that resolution, which decided that there will be some exceptions for mining in that region. So the company, if Colombia behaved the way it did, had legitimate expectations to undertake the mining exploitation activities in its concession. So the tribunal found Colombia's conduct to be arbitrary and disproportionate. So again, principles of arbitration and principles of investment law coming into play. So because the decision was arbitrary and disproportionate, and this was not justified for any other reason, there was no other apparent purpose why the decision was taken the way it was. So therefore, it can only be concluded that this was arbitrary and disproportionate on the part of the government of Colombia. And therefore, because of the breach of Article 805 rights, the tribunal concluded that EcoOro is entitled to damages. And as of now, the damages are still being calculated. So we only have the decision in favor of EcoOro for the violation of its rights under Article 805. By the way, the EcoOro wants a compensation for the indirect appropriation to the tune of about $650 million US. We have to see how the damages are calculated for the breach of 805, which is different, of course, to 811. So what is Article 805? So this is about the minimum standard of treatment and then the fair and equitable treatment principles, MST and FET. So we're going into the core of investment law jurisprudence. So Article 805, each party shall accord to the covered investments treatment in accordance with customary international law minimum standard of treatment of aliens. So this is a key term. So there's a minimum standard of treatment of these investors who are aliens to Colombia. And it's customary international law that determines the scope of the MST, okay? And in this FTA, it was very clearly agreed that any other standard for treatment of aliens is only included or part of the MST. It doesn't give anything over and above MST. So the other standard is FET, so fair and equitable treatment for aliens. And the other standard is full protection and security. So whether it was fair and equitable, full protection security, everything can be subsumed under the term of minimum standard of treatment of aliens. Okay, and that's clearly and explicitly mentioned in the second part of Article 805. The concepts of FET and full protection security do not require treatment in addition to or beyond that which is required by the CIL-MST treatment of aliens. Okay. So from Article 805, what do we then conclude? The minimum standard of treatment of aliens is what Colombia owes to ECOAURA. Okay. And what was then decided by the tribunal was that this standard was not kept with respect to ECOAURA. We'll see how they reasoned that out. And then we'll also look at, there was a dissenting judgment in this case for this particular part of the judgment. And we'll look at the reasons for the dissenting judgment. And then we can decide which way you think should have been decided. Yeah. So whether 805 should have been decided in favor of ECOAURA or should have been decided in favor of Colombia. So for that, you need to understand more the concept of MST and FET. Some of you who are doing investment law are probably familiar with this, so bear with me while I take you through this. But others, you'll have to note how the interpretation of MST is relevant in the context of climate litigation. So the standard of protection which has been granted to ECOAURA is MST. How do we know what exactly is the minimum standard of treatment? We need to look at what customary international law lays out for this. Okay. But in this case, it was a question of the relationship between MST and FET. How they are delineated. And that's what we'll be looking at. So the standard to be applied by this tribunal is not the fair and equitable treatment standard. And fair and equitable treatment standard is something that is found and is applied in a large number of investment protection treaties, not in the 2008 Canada-Colombia FTA though. So we have to be clear about that. It is certainly part of investment law, but it is not the applicable provision for this particular context. So having established that, this is part of the reasoning by the majority in the judgment. Okay, the majority that decided that 805 was being breached by Colombia, and therefore ECOAURA had the right to damages. So the first statement that they established, okay, they said, the majority observed that the meaning of MST must be permitted to evolve as indeed international customary law itself evolves. So this is a very significant statement. You can find it in paragraph 744 of the judgment of the majority. So what is significant about this? Later on, the dissenting arbitrator is going to argue that the starting point itself is wrong. Yeah, because what they are saying is there is an international customary law principle of MST, but what they are going to apply over here is an evolved version of the international customary law principle of MST. Okay. However, they don't go into any more detail about the evolution of it. They say that the MST, they are following MST, but that MST has actually evolved because customary international law evolves. That statement is part of public international law for sure. Okay. The whole idea of having customary international law is that it's much more fluid and it evolves with state practice and opinio juris. Okay. Whereas if you said that MST is a principle only accepted in the positive law in the treaty, then you are restricting the scope of it. So that is the flexibility that the majority have used to place this interpretation of MST in this particular case. So what they've said is, as a starting point, we are saying that the MST has evolved, which means that there is a higher standard for the minimum treatment of aliens, even as per international customary law. Now, once they've established this, you can see how they can now move closer to the fair and equitable treatment standard. Okay, so then they go on to look at some of the facts of the case. So the references that were made to a predictable commercial environment as an expectation for any investor that is investing in the host state, as well as there were references to the environmental matters, all of which is present in the preamble of the free trade agreement itself. So the majority found that EcoOro was entitled to expect that Colombia would treat its investment in an even-handed and just manner to ensure a predictable business environment. And they would, of course, take into account the environmental laws and regulations as they evolve. Okay, so they're laying the ground to basically say that the all parts of the FTA need to be taken into account when interpreting MST. Now, in addition, the majority also found that the violation of MST would require some aggravating factor, such as the acts identified that comprise more than a minor derogation from which it is deemed to be internationally acceptable. What does that mean? Okay, what we're saying is this minimum standard of treatment of EcoOro is this, according to international customary law. And in order to say that Colombia did not provide that minimum standard, you need something quite serious, yeah, aggravating factor. It cannot be a minor derogation. So MST, even at the standard established by this majority, for violating it, requires something serious that the Colombian government has to do, okay? It cannot be just a minor derogation. So those are two factors that the majority have to establish has happened in the case of Colombia in order to say then that 805 article of the FTA has been breached by Colombia, and therefore EcoOro needs to have compensation. So they're applying this standard of MST, which is basically the evolved customary international laws idea of MST. They're using the facts. So the majority first noted that Colombia has granted the concession in full knowledge that the concession area overlapped with the Santrobán Páramo. It had an obligation to protect this area against environmental harm. All of this we've gathered from the facts of the case. The majority further noted that EcoOro continued to receive encouragement from Colombia with respect to its concession because it got some environmental awards even. And like I said, it was given as an example. It's a good example to follow for mining projects. So there was encouragement and support that was given by a part of the government. And then finally, the majority also considered that despite the various laws, resolutions, and court decisions, we saw the whole history of how different institutions, the executive and the courts, got involved in various parts that related to the mining project. They imposed an obligation on Colombia to delimit and acquire the Páramo areas. And Colombia was, or the government was, consistently failing in these as well. They did not fulfill their own court's judgment. So the majority arbitrators in this panel essentially decided that all of this indicated that the Angostura deposit cannot be said with any certainty to be within the Santrobán Páramo. They now create the possibility that EcoOro may be allowed, despite the fact that the particular special Páramo region is protected, mining can still take place, because a combination of the law, resolution, and court decisions still does not give any certainty of expectation that this area is going to be fully protected. So the majority, taking into consideration all of this, they decided that Colombia's government actions were internally inconsistent, including its failure to delimit the Santaban Paramo and also denied Eco Oro a stable and predictable regulatory environment in reach of its legitimate expectations. Yeah. Well, every statement that has been made over here is correct, but we also have to consider whether this is the standard to which the government of Colombia needs to be held under the FTA 805 obligation of Customary International Law, MST. So that's the key question that we have to remember. Yeah. Nobody is denying that Colombia took all of this time to do what they did, or they were basically in breach of their own environmental obligations under the Constitution. But the question is whether all of these activities amount to a breach of MST, or is it actually a breach of FET? Okay. So having completed that analysis, they took the next step. This is about arbitrary and unjust action of the government of Colombia. They did find that Colombia's frustration of Eco Oro's legitimate expectations was unjust and arbitrary. So it was not just that Eco Oro was frustrated with how the government was behaving, but all the activities of the government amounted to it being unjust and arbitrary. And they supported their decision or their conclusion by specifically pointing out to the fact that Colombia did not fulfill its statutory duty of delimiting the Santaban Paramo. They also specifically mentioned this tension between the environmental ministries and the mining ministries. The majority focused on the competing approaches within the Colombian ministries, one to protect the Paramo, another to secure economic benefits from exploiting the region. So a complete lack of agreement or even coordination, resulting in a near failure to resolve the competing demands. Yeah, so they were just really talking about what the situation was, something that is not, unusual in governments, particularly in the developing country governments as well as the LDCs, for a number of different reasons. And finally, the tribunal noted that Colombia had refused to allow Eco Oro a time extension to submit its PTO. Simultaneously, it also did not complete the delimitation and was taking its own time. It didn't grant Eco Oro extension, but it granted itself an extension to take time to delimit the Paramo. So taking as a whole, the majority found Colombia's approach to the delimitation of Paramo to be one that inflicted damage on Eco Oro without serving any other apparent legitimate purpose. Statements that were repeated. Okay, so this was the decision on 805, and the summary to that essentially was the breach of the minimum treatment of standards that are required to be provided for aliens under the 2008 FTA. Okay. Now we look at the counter argument for this. So you would have guessed by now that Philippe Sands, KC, who was the one of the arbitrators in the panel, he did not form the part of the majority decision that found a breach of 805 by Colombia. Philippe Sands, KC, was also appointed, by the way, by Colombia as well. Okay, just to mention that. So his partial dissent, because he agreed with the decision on Article 811, but he did not agree with the decision on 805. So his dissent is explaining the reasons why he did not agree with the final outcome, the majority outcome, with respect to Article 805. And his dissent was quite straightforward. What he contended was that the majority judgment in Article 805 fails to respect the text that was agreed by the drafters of the FTA. And in addition, he also claims that it's likely to undermine protection of the environment. And this is important for us from a Paris Agreement perspective, a carbon sink perspective as well. Okay. So to remind us, what was the text agreed by the drafters of FTA? Maybe I can put that question to you. Does anyone remember? What was Article 805, the wording in Article 805? Anyone?
I think I cannot remember the exact wording, but it was talking about the damages that might have been caused to the company from, is it Ega or whatever from Canada? But I cannot remember the exact wording, what it talked about in terms of the damage, how that should be paid and whatever.
It's not about damages, no. Try and remember.
Fair treatment, Professor. Minimum
Say that again.
Professor, fair treatment. Fair and equitable
Fair treatment. Yes, exactly. It was about that, but do you remember what the text was talking about? Does the foreign investor need to be given fair treatment, or does the foreign investor not need to be given fair treatment?
Not, Professor.
Fair and equitable treatment principles should be provided.
Should be? No. Pankaj, what did you say? Should be or should not be?
Should not be.
Should not be. So instead of fair and equitable treatment, what should be given?
Professor, it should be given according to the customary international law.
Yeah. So the minimum treatment required under customary international law. So it should not, very specifically, the text said that fair and equitable treatment should not be beyond the minimum required. Okay. And full protection and security also need not be given, only the minimum standard needs to be given. Okay. So this is where Professor Sands' dissent comes. He says, yes, I agree. Colombia did act in the way they did raise the expectations it did, but only if the standard is supposed to be FET or full protection and security, can you hold the government of Colombia to those standards. What is really required now is only the minimum standard of treatment. And also, if you want to find that there's a violation of minimum standard, something really serious, something very egregious has to be identified. It cannot be on a minor violation as well. So both of these. But the main point of Professor Sands is that the majority is failing to respect the treaty provision itself. Okay, so let's look a little bit more into his dissent. So now he is presenting an argument for how the principle of customary international law is also part of what needs to be considered an interpretation of 805. So he's citing previous decisions, and he talks about a ICJ case, one that was that took place in 2007 around the provision of the scope of minimum standard of treatment versus the FET and full protection. And the ILC, the International Law Commission's articles on development of customary international law also acknowledged that even though a number of investment treaties now are starting to include FET, or they all have included FET, by no means the inclusion of FETs in several investment treaties around the world has now led to the FET becoming the minimum standard of treatment. Okay, so he's starting off by establishing that both a judicial authority as well as the most authoritative source on international law, which is the International Law Commission, whose job it is to codify the progressive development of international law. And one of the main jobs in that is to revise and to look at the content of customary international law as it evolves. Yeah. So remember what the majority judgment said before they went on to assess what kind of treatment was given under 805. They laid out a statement. They said, as a preliminary matter, we take into account that customary international law also evolves. So they were trying to establish a standard somewhere between the current minimum standard of treatment of aliens, the FET standard, and somewhere in between was where they are trying to pitch their standard at which eco-oro needs to be treated. Whereas that is what Philippe Sands is trying to shoot down in his analysis by saying that the customary international law for the minimum standard of treatment has not risen anywhere above where it has always been. And for that, he's talking about the ICJ and ILC positions. In fact, he also suggests that many investment treaties, by including the fair and equitable treatment provisions, supports the conclusion that is opposite to what the majority have brought about. Meaning, the only reason that they had to include the FET standard is because it is not customary international law. Okay, so the widespread inclusion of FET provisions support the opposite conclusion. States which include such provisions in the treaties may be understood as expressing a desire to depart from the standard in customary international law. So he uses this position saying, if many investment treaties mention FET, the reason they have to do is because they have to differentiate themselves from the existing standard, which is the MST standard. And he agrees, okay, he agrees with the majority that customary international law will evolve. Yeah, but there is a way in which it will evolve. So how does that evolve? The majority should have analyzed and showed how state practice and opinio juris, the two important elements to demonstrate that there's customary international law, has now changed against MST in favor of FET. So the majority took that as a given without having established what is the state practice around this, what is the opinio juris around it. Okay. So what he's saying is that customary international law has not evolved as far as the minimum standard of treatment of aliens is concerned. So the majority have made no effort to address the evidentiary requirement, i.e., state practice and opinio juris, and then they have ignored the explicit requirement of the FTA drafters that the claimant must prove the content of the rule of customary international law that's invoked under Article 805. So coming to that key position of his, which is you cannot move from the letter and the intent of the law of the FTA 2008 by finding that Colombia violated Article 805, they have interpreted the 805 article wrongly. So that's his dissent. He also then talks about some of the facts that the majority used to support their decision. So he says, as outlined by the majority in this case, the starting point in determining whether a state's conduct has breached is whether it has acted in a way which is arbitrary or grossly unfair or discriminatory, or otherwise inconsistent with the customary international law standard. So now we're coming to that second aspect where if this is a particular standard, what is required to identify that there's a breach of that standard? So there must be grossly unfair, discriminatory, arbitrary treatment. So the threshold for determination of a breach is also high. The threshold should reach the levels where the state conduct must be considered as egregious and shocking. And it should lead to an outcome which offends judicial propriety. Okay. So what we are saying is it has gone to the stage of being almost quasi-contractual. So that's when it'll offend judicial propriety in the sense that you can make a judgment saying there is a breach of a certain type of a right. Okay, so that means the standards for saying that Colombia has acted in a manner that's arbitrary in this FTA needs to reach the highest standards of it being very serious, very shocking. So in applying the standard, it's important that the tribunal's analysis is made in the light of high measure of deference that international law generally extends to the right of domestic authorities to regulate matters within their own borders. So if you consider the activity of a government, if you think about the complexity with which government acts, the governments need to be given that ability to handle their own domestic matters in a way that they see fit. Yeah. So what is being essentially said is that the government's actions to be considered as shocking and really bad is not that easy at all. Okay, it doesn't really happen often. And it doesn't seem like what Colombia has done now amounts to that. Yes, they have not they may have been in contempt of court, of their own constitutional court, because they didn't carry on the delimitation of the Santurban Paramo. Yes, but all of that still does not make the government's action egregious or shocking. Now, this is where the wider context has to be taken into account as well. You have to look at the whole of the government of Colombia and look at what is their environmental track record. Okay. Now, Colombia is supposed to be one of the leading countries for its environment. And at the time when this case was going on and the period before this case, so if you take the period from 2007-8 onwards, when this concession was granted and the different laws from 2007 to about 2016, there were, the government had a very good environmental record. It was able to increase large areas of protection. So overall, the government was making quite a bit of progress in protection of the environment. So from that perspective, the charge that the majority brings against the government saying that they have not implemented their own constitutional court, there may be a defense for the government saying, you know, there are a lot of reasons why we have not been able to implement the delimitation per se. Okay, so from Professor Sands shows the action of the government of Colombia in different light to explain that they do have a right to regulate their own matters in their own way. And if you want to consider the Colombian government as not protecting the environment, that's not true as well. So essentially, ECOAURA has offered no plausible evidence to support a different standard. So they have applied FET, but they've not showed any evidence of why that FET should be applied. And the majority has cited no authority or evidence to support its conclusion. So again, saying that the application of FET as MST is a misapplication because they've not supported their conclusion of using that. Finding of bad faith or malicious intention on the part of the state is not required because the threshold for finding the breach of MST nevertheless remains very high. So we're not saying that according to the Article 805, in order for the state to be found arbitrary to be found acting unjustly, there needs to be bad faith demonstrated or malicious intention, which is perhaps the highest threshold. But nevertheless, there is still a very high threshold that needs to be established. And such a finding that it has breached must be based on facts which are truly exceptional. So again, trying to say very serious, very exceptional. Although the ordinary decision-making process of state may result in the breach of the FET standard, a breach of the MST is not an everyday occurrence. So what he does accept in his defense is that an FET standard has been breached by Colombia, but an MST standard has not been breached by Colombia. And Article 805 of the FTA only requires an MST standard to be maintained, and the majority is wrong in applying FET and then finding Colombia to be in breach of FET. Okay. Some of the reasoning he also goes on to address, but I'm not going to go into all of those. I'm just going to pick up only one of them. So according to Philippe Sands, he identifies how the majority has constructed the breach of MST by Colombia by looking at three intertwined strands of reasoning. First one, the respondent breached the claimant's legitimate expectations. So the government of Colombia breached ECOAURA's legitimate expectations. And this is the only strand that I'm going to talk about in a little bit of detail. The second strand of reasoning for finding a breach of MST by Colombia is that Colombia failed to provide a stable and predictable legal environment. And thirdly, respondent acted arbitrarily in its dealing with the claimant. The principles applied for showing these three strands of reasons are actually similar. So that's why I just pick up one of them. And according to Professor Strands, this particular approach that the majority of the tribunal is applying is novel. So he's putting it mildly. He's not saying it's wrong. What he's saying is it's new, it's novel, meaning it doesn't provide legal certainty, meaning that they shouldn't have applied this. And he says, I disagree with the majority's reasoning in relation to all three strands. Because if he does agree with all three strands, then he has to agree and be part of the majority decision, not be a dissenting arbitrator. And he does equivocally say that there is no evidence to support the approach to the MST standard that is taken by the majority. And there is no reasoned support for finding there is a breach of it. Yeah, these are two different things, right? The first was establishing the level, whether there is any change in the MST standard. But the second is about finding the breach. And that finding the breach is based on these three reasoning that he's talking about. Colombia did not meet the legitimate expectations of the investor. Colombia did not provide a stable and predictable legal environment. And Colombia acted arbitrarily. Okay. And Professor Sands' argument is that none of this is really fitting the standard. So just looking at this concept of legitimate expectations, and three key expectations are laid out by the majority that the claimant has. One is it's entitled to undertake mining exploitation activities in the entirety of the area of the concession. In the event that the state were to expropriate, then the investors acquired rights and they have to have compensation paid to them. And thirdly, Colombia would ensure a predictable commercial framework for business planning and investment. So we've seen all of this in the majority judgment mentioned as well. There is no evidence before the tribunal to establish that the respondent gave a quasi-contractual commitment that the claimant would have rights under any of the three counts above mentioned. So this is a summary of the provision saying the standard at which these expectations need to be fulfilled seem to be at the level of nearly contractual rights. So at the level of being a quasi-contractual agreement is how the majority is pitching this interpretation of legitimate expectations. And that, again, is the problem. There is no contract, quasi-contractual obligations, anything over and beyond what is there in the FTA and the mining concession agreement. Okay, so the final point here in defense of the Colombian government is this notion of a prudent investor. So Professor Sands is claiming that under the investment law, anyone investing should really do due diligence, should assess whether this is a risky investment or not. So there is a duty for the investor to act prudently. And it is within that background that the legitimate expectation has to be interpreted. Yeah. So the tribunal has recognized that in order to rely on a claim of legitimate expectation, investor must show that its expectation would have been shared by a prudent or reasonable investor. And in order to be acting as a prudent or reasonable investor, they must have engaged in some sort of due diligence. There's nothing in the record to show that any due diligence was undertaken by Eco Oro in respect of any of the representation upon which it is supposed to have relied on. Okay, because even if they took a minimum cursory due diligence, even before the concession was given to them, they would have known the potential existence of the Paramo ecosystem within the boundaries of the concession. It was no secret, right? The landscape was there. The characteristics of the landscape were identified way before the actual legislation did come about. So any investor should have expected that this is going to become quite high in the agenda. And then if you think about why, this would be high in the agenda, we are now talking about the 2007. Even in 1994, the Earth Summit, the whole idea about climate change, the UNFCCC having come into existence, all of these, the legal department would be aware of, those who have to do the due diligence on part of Eco Oro. So from that perspective, the existence or the importance of such a ecosystem was already known, right? So the government's commitment and obligation to protect these ecosystems, of course, goes without saying. Environmental laws in Colombia already existed. So even if if Paramo ecosystem was not relevant as a carbon sink, it was still relevant as a precious ecosystem for the flora and fauna itself, for the habitat and for the species itself. And that the government had a commitment to protect these. Such a protection could be achieved by imposition of a mining ban. So that is also definitely potentially expected through due diligence, that there could easily be a mining ban in the region. Eco Oro had no distinct reasonable investment-backed expectations that exploitation would be permitted in the entirety of the concession area. So at no point in time that they would have expected that they could do open pit mining in the whole of the area. Appropriate due diligence exercise would have advised Eco Oro that Colombia could retrospectively impose a mining ban. So there's quite a whole list of how a prudent investor should have behaved, and stating that Eco Oro did not behave that way. So as such, we need to ask questions then. So what does this decision mean? So this new generation of free trade agreements sounds quite good, because the new generation of free trade agreements allows for national laws to protect environment and to restrict the rights of investors whose activities will impinge on the environment. But despite having a new generation FTA, despite the 2008 FTA between Colombia and Canada being a new generation FTA incorporating protections for the environment, it still has led to the government of Colombia being penalized because they protect the environment. So you could have two arguments here. Well, at the end of the day, the environment is protected now. So that seems to be fine because 811 did not strike down the environment law. They said this was not indirect expropriation. It is a legitimate public interest that was protected through the environmental laws protecting Paramo. So you could say, well, that's correct. What the government is doing is only paying damages because it treated Eco Oro in an, with the minimum, not giving the minimum standard that it was supposed to be given under customary international law. But then what are the implications of that? Eco Oro is already asking for $650 million US for the expropriation. So they might probably be asking around the same amount for the arbitrary and unjust, which they will not be allowed. There's also, the same judgment that lays out the principles on which the damages need to be paid. So it's not going to be the same amount, but it's not going to be a trivial amount either. So you might say, okay, if the rights of the investor are effective, then fair and square, they have to pay the money. Okay, government of Colombia has to pay the money. But we've got our objective of making sure that the Paramo environment is intact. But now come to the broader picture of climate finance. Yeah. So climate finance, look at the country of Colombia. Country of Colombia is a developing country. It is not a least developed country. It is a developing country. According to the IPCC reports, according to the risk assessment, the costs of adaptation measures in Colombia is rising, as it is rising in many countries where the costs of adaptation are higher than the costs of mitigation, because Colombia, again, is not an Annex 1 country under UNFCCC. It does not have the same obligation as industrialized nations, but it also has an obligation to take adaptation action. And the loss and damage that is coming from climate change is also causing loss in Colombia. And in the absence of climate funds enough to support developing countries, what do countries like Colombia and other developing countries do? They borrow money in order to be able to provide for or repair all the damage that is caused by the disaster events, or they borrow money to make sure they build resilience in their communities, in their different sectors to adapt to climate change. The borrowing costs are increasing. So the sovereign debt increases. Colombia's sovereign debt is also increasing. In a recent report that the World Bank released, there are about 70 countries in very high debt. It's not in the same levels as some countries like Sri Lanka, which is now really reeling in debt. Colombia is also very high. And given the background of, a lot of the 50-year, 60-year violence that has taken place there, which has led to a lot of deprivation and need for rebuilding. So taking this all into account. So put the compensation that the tribunal requires Colombia to pay Eco Oro, it's a cost that the taxpayer will incur to the tune of 300, 400 million USD, and put that in the context of the wider picture of the amount of costs that countries like Colombia are needing to face because of the impact of climate change alone, yeah, the adaptation and the loss of damage. So from that perspective, you've got to look at the context of whether a desired result is being obtained in the context of climate litigation. So this is one example of a case which is a good case because it takes into account some of the big tensions. Yeah, so free trade is essential. At the same time, environmental protection is essential. And also the role of the judiciary in this case, it was about protecting the participatory rights of peoples and communities. Yeah, and we know already that when it comes to climate adaptation and also when it comes to mitigation in many cases, the role of more than just the scientific techniques. We need the best available knowledge, which includes informal knowledge, etc., is quite important. From that perspective, empowering of the people by the judiciary, by the Colombian Constitutional Court in this case, was legitimate. Yeah. So that's why this case is quite interesting to see some of the big players and big principles being brought into play. Okay, so I think we need to take a break quickly, but before that, I'm going to stop sharing and invite some thoughts and comments as you listened to me on this case and me analyzing the case. Temur.
I like the position of the arbitrator who didn't agree with the judgment, and I think it should be fully set aside in the future, because really the EcoAura, I think the name of the company, they knew from the beginning about overlapping and why doing investment into areas under question, 54%. Okay, you are an investor. There is an area under question, but you can invest in this situation into those areas that are free, definitely. And okay, why waiting so long? When they understood that the limitation is not coming soon, and that there are no clear terms for the government to do this delimitation, why not go into the court immediately when they understood there is some sort of violation? And why being agreed with those suspensions given by the government for 3 times maybe? So it is not fair to ask for compensation in this situation. I think there are no grounds. It looks like more an attempt to exercise it is a sort of play in front of investors to justify a bad management. It looks more like such an attempt. Hopefully it will be set aside.
Well, it depends on whether they appeal, right? They're waiting for a judgment on the damages as such. So we'll wait and see what happens and how much damage is actually finally awarded. Mika had his hand up.
Yes, thank you. I think reading through the case or following you through the presentation, I think one thing that was successful, whether the majority did the right thing or they misinterpreted the law, one thing that was clear is that they were able to preserve the environment. Carbon sink was, they were able to do that. So that is one. The only problem here is the side of the compensation and all that. And just a disclaimer, I'm not a lawyer, I'm not a lawyer here. I'm not a student lawyer or anything. But I've seen in clear cases where sometimes, based on my layman knowledge, I see that people enter into contractual agreement trying to find some loopholes in certain places where they can succeed. For example, it's very clear when it goes to the road and transport sector, construction areas. This is very clear. Contractors enter into agreement with entities and all that. They know that this probably is not supposed to be, but it is in the contract. It is left onto the person entering to the contract to determine if this is right or wrong. So you can either amend the contract before you agree or not. So in this case, although I agree with the individual who did not go by the majority, but the justification is given. Of course, there are obvious justification, but it is based on those obvious justification that one is able to succeed or play against another person's mind. What if the company knew all this, but were trying to, override what was seen? So it was left onto the government of Colombia to to know or decide, okay, this might be what will happen in future. For example, when you go to the transport sector, you see that a contractor enters on an agreement with the government or something, knowing very well that the initial mobilization for the contract will not be enough, but they still enter. They work for 1 or 2 years and they stop work. When you ask them, they'll tell the government haven't paid for maybe this certificate. And at the end of the day, they wait for 5-6 years and apply for what they call it, advance or compensation for payment and order before they continue. And government has to pay. So that's what I'm saying. I'm not a lawyer, but I see some of these things happening. I'm just trying to, play that in this shoe to see maybe they knew what could happen in future, but by then the fault was on the government of Colombia to know that this could happen in future and to find ways and means to mitigate that before it escalates. But that never happened. But if we link it to the Paris Agreement, I just wanted to have a question. So in this case where the government of Colombia has been able to preserve the carbon sink, yet they are under a fine to pay huge sum of money. And taking the stock take, this was a success as far as protecting the carbon sink is concerned. So what is the Paris Agreement going to do to support Colombia in ensuring that they are able to cover this fine? So that next time, maybe another country in this particular situation will also stand firm to protect the carbon sink. But if nothing is being done to support them, maybe another country may not have enough money to pay for it and will go by whatever consequences it may have on the climate. So I'll just ask them, is there any agreement somewhere in the Paris Agreement that can support or maybe speak for countries that may be highly indebted as far as climate change payment is concerned?
Yeah, I actually have a video to play, so we'll discuss this after that particular video. So, well, yeah, thanks, Mika, for your thoughts. Oleg.
Yes, I couldn't agree more that that's outstandingly bad decision in the matter of the both abuse of the system of the ISD system and the threat to climate change protection, as well as inherent problems of the climate system itself. It's outstanding and remarkable for blatantly ignoring the undisputed party submission of the Canada. So the tribunal just went on to say that it doesn't matter what does the parties say, we just interpret it in our ways. And the assignment of the cost on specific parties here, it's not clear to pay for parties or to pay for the things. They just need to make business. And there is not stabilization clause here. There is no things or interpreted minimum standards of treatment in this way is very, very contrasting with others, in Glamis Gold and other decisions. Yeah. Okay, it's not also a very good example, but the difference is straightforward, it's opposite even. And this way they basically say firms don't need to put into efforts. We rely everything on governments and then on the taxpayers. And how is that possible? So I think that's a step backward.
I agree. It's actually bad investment law, isn't it?
Yes, but it's bad application of investment law, and it's not clear why those who promote it are not responsible for that. It should be also repaired.
Yeah, the other arbitrator was not the chair, but the other arbitrator was from Argentina. And I mean, I've not looked enough into the decisions to see what their interpretation is in other cases, but it looks like they had very different arbitrators. Philip Sands has more of international environment leanings as well. So he looks at it both ways. But overall, even for investment law, yes, it's pretty shocking how the customary international law was just glossed over by saying, of course, customary international law will evolve. So I would say probably it is bad international law decision per se, because everything fundamentally rotated on this idea about has customary law, international law evolved or not? And it's a fundamental mistake not to establish the state practice and opinion juris to support an FET standard as the minimum standard. So I agree. We need to get areas of law really well if we want to have better protections under Paris Agreement. Yeah, there's no point in having a progressive free trade agreement and progressive investment clauses in the free trade agreement if they're not going to be interpreted as they really should be. That comes down to us lawyers then and the arbitrators. So if you guys are going on to arbitrate, then you're going to have to, do it properly and do it well. Just do your jobs really well, I would say. But feel free to use this case law if you want to pick it up for your analysis as well. And, look at all parts of the judgment, and maybe your interpretation might be different. So I leave that to you. Excellent. Shall we take a break before we go on to the next case? Yeah. On my clock here, it's 4 minutes past 8 for you guys, right? Or is it something like that? So shall we get back about 8:15?
Yeah, let's do a short break. Coffee break.
Excellent. Yeah, a short break, a comfort break. think everyone is here. So let me play a video now for you guys, just to, so we're reminding ourselves of this concept of climate justice. Okay, we've done climate law, right? But we've got to understand that the Paris Agreement places a lot of emphasis on justice. Why do I say that? Right from the UNFCCC agreement, you had this principle of saying it's not fair that those countries that didn't contribute over the years from 1850 onwards to greenhouse gas emissions should now also take the same measures as countries that have contributed. So that principle of justice is embedded in the Paris Agreement. Yeah. In fact, it is embedded in environmental law for the first time through the climate regime. So that's just one fundamental example of the notion of climate justice. But we've got to ask the question about the principle is there, how far is it being implemented? And in that decision with the Eco Aura Mineral Corps and the Republic of Colombia, I raised the question about should Colombia, be asked to pay compensation? You could look at it from the perspective of that case law. And since there's a breach of rights, yes, you've got to compensate the other party, but you also have got to look at it from the broader context of climate justice. Okay, so bear that in mind as you watch this video. Let me share, and you have to then just tell me about the sound, whether you can actually hear. All right, so let me play. And give me a thumbs up if you can hear.
No, we can't yet.
You can't hear?
No, we can't.
Okay, let me try again. What did I do last time to get the sound going? Share. Standard sample sound. Include computer sound. Brilliant. Okay, this should be fine now. Let's see.
Climate justice.
Can you hear now?
Yes, yes.
What do we want? Climate justice! Climate justice now.
2 words that we hear more and more.
That climate justice is linked to racial justice, social justice, and intergenerational justice too.
This is why we call not only for climate action, but climate justice.
2 words that could define the century.
There is no climate justice without racial justice. There is no climate justice without gender justice. There is no climate justice without queer justice.
But what exactly does climate change have to do with justice? Aren't we all in this together? To understand climate justice, we need to understand climate injustice. Who causes climate change, and who's hurt by it? Let's first look at who's responsible for putting carbon dioxide into the atmosphere and heating the planet. Imagine this grain of rice is 1 ton of carbon dioxide. Each year, the average person in Nigeria adds less than 1 grain into the atmosphere. The average person in India, 2 grains. In China, 7 grains. In Germany, 10 grains. In the US, 17 grains. In 1 year, the average American pollutes 20 times more than the average Nigerian. But the problem with carbon is that it stays trapped in the atmosphere for centuries. So it's not just about how much we add each year. It's about how much has piled up over time. Since 1850, that adds up to about 1,500 gigatons. Okay, so we wanted to pour loads of these rice bags on the table to show you how big that really is, but after doing the math, we realized we need 3 million of them. Historical emissions matter today because countries are arguing about how soon they have to cut their net emissions down to zero. Big polluters like China, India, and Brazil look a lot less guilty when you consider they've only recently become part of the problem.
Their tendency is to quote the annual emissions, but that doesn't tell us anything about, why we are in the current mess.
This is Prakash Kashwan, a political scientist researching climate justice. He says rich countries haven't accepted how unjust climate change really is.
It's mind-boggling, the kind of inequalities that have brought us to the current climate crisis. They're unbelievable and they aren't talked about enough.
In 2020, researchers calculated how far each country is responsible for pushing CO2 levels beyond a safe threshold that we crossed in 1990. The study takes into account how many people live in a country, how much they emitted throughout history, and includes emissions that cross borders through traded goods. The research shows that rich countries have outspent their carbon budgets. By a lot. The global north has emitted 92% of the CO2 that pushed the planet beyond safe levels. Asia, Africa, the Middle East and Latin America have emitted just 8%. Even a massive emitter like China is only just using up its carbon budget now. But if you live in a country that runs on fossil fuels, this doesn't mean climate change is your fault personally. But some of your choices do still make a difference. Because it's not just about where you live, but also how much you spend. The world's richest 1% emits twice as much as the poorest 50%, and those elites live all over the world. Unequal emissions are one big reason why climate activists are shouting about justice.
Everyone already is affected by the climate crisis, just on a very different scale. But if we look at the people ruling Germany and sitting at these decision tables for the past decades, they have not faced their responsibility.
They are destroying our environment. I think they need to act now, not later.
But hold up. CO2 heats the planet by the same amount whether it comes from Germany or Kenya. The climate doesn't care about geography. Well, geography cares about the climate. The second part of climate injustice is that even though poorer countries have done the least to change the climate, they're the ones getting hurt the most. Take heat waves and drought. Heat waves are becoming most unbearable across Africa, where droughts are even more punishing for crops. Then there's storms. Warmer air means that hurricanes and typhoons carry more energy and unleash more rain and stronger winds across the tropics. And by 2050, sea levels will have risen so high that floods which used to hit once a century will strike many coastal cities every single year. You can check out one of our other videos to see how some cities are trying to keep themselves afloat. The inequalities of climate change come together hardest in a country like India. Even though its people have barely contributed to global warming, they're among the most vulnerable. India's coastal cities are facing unprecedented floods while its rivers dry up, leaving farmers struggling to grow staples like rice and wheat.
India is one of the most inequitable countries in the world, and what we can see is that even if you take a city like Mumbai, when floods happen in the city, it's the poor that are the most impacted.
This is Payal Parekh, a climate scientist who campaigns full-time for climate justice.
Having grown up in a country like India, I grew up with inequality all around me. And this is essentially what it comes down to. The world is very unequal, and it's playing out in terms of climate change as well.
But that inequality is found within rich countries too. Black and brown people in countries like the US or the UK are typically poorer than white people. And that means they have less money to spend on air conditioning to adapt to heat waves or flood insurance to rebuild after storms. So, how can we make it fairer? Well, polluting countries can first turn off the CO2 tap and start removing their pollution from the atmosphere. Then they could pay reparations for using up more than their fair share of emissions. Some countries and companies are already doing something similar by paying poor countries to not chop down forests and instead plant trees. But instead of using that saved carbon to atone for their climate debts, they're using it as an excuse to keep on emitting.
So climate reparations have to be part of that discussion, and climate debt in particular is where we think about who is, we kind of divide up who is responsible for the kinds of ecological changes and climate changes we're seeing in societies, but also the kinds of climate-induced disasters that countries are facing.
This is Keston Perry, a political economist studying climate justice. He says reparations are needed to balance the scales, but that they won't be enough.
It is an interim measure. When I say that, I mean it has to be, we have to have a sort of much more longer term conversation around the economic system that we have nurtured and cultivated globally that have resulted in these kinds of disasters. And what do we do to not only reform that system, but absolutely overhaul it?
Reparations might sound radical, but rich countries already agreed to pay poorer ones to adapt to climate change. Imagine each of these Ps is $1 billion US. Rich countries promised 100 of them each year in climate finance by 2020. But it's 2021 and they haven't coughed up. In 2018, they gave 80 billion, but most of it was loans, not grants. UK-based charity Oxfam found that the real aid was actually closer to 20 billion.
Yearly, we have not been meeting the kinds of targets that even global north countries have set themselves. That finance mechanism is not meant to actually solve the problem.
Another approach takes climate justice more literally, holding polluters to account in court. After deadly wildfires tore through Portugal in 2017, 6 young activists took 33 industrial countries to the European Court of Human Rights for failing to cut their emissions quickly. They argued that the countries are discriminating against young people who will have to live with the consequences of climate change. The verdict is still pending. In Germany and the Netherlands, High Court judges have ordered their governments to up their ambitions on cutting emissions. Activists also won a case against Royal Dutch Shell, forcing the company to pay for oil pollution, and are now demanding climate-friendly investments too.
So the basic legal argument for assigning responsibility is your contribution to the problem. So how much do you emit? How much do you contribute to climate change, greenhouse gas emissions? And what is the possibility for contributing to the solution?
The defendants argue that national courts don't have the right to rule on the climate because emissions and their impacts are global. But a new generation of activists are fighting for them to take exactly that responsibility and give them climate justice.
People have no idea how unjust the climate crisis is, and that's why we're making videos about it every Friday to help you understand. So if you like what you saw, then hit subscribe.
Okay. So Mika, did you get any answers from that video?
A little bit, not too clear, but I heard something regarding some monies, but the person is not giving us a grant. It's actually giving us more than loans. And if you give me a loan, it's equally the same as me owing somebody. So, but if it had come as a clear-cut grant from you to, meet that problem, it's better.
Yeah. Well, that's what they're arguing for. So there is a concept called climate debt. Okay. This is not, part of any legal framework, but this is what the activists, that were being referred to in that video are asking for. Climate debt might sound, like a usual term, but it's actually quite unusual. What they're saying is that the countries that have emitted cumulatively the most so far actually are in debt to the countries that haven't emitted. So what they're saying is you cancel the sovereign debt of countries who haven't emitted so much so far by fulfilling your climate debt to these countries. Okay, so sovereign debt is created because, you know, Colombia is spending money to repair the damage that's been caused by climate change events and disasters, or they are spending money to adapt to climate change. So now they borrow money in order to spend that money. Now that borrowed money, yes, you know, they have to pay off the capital, but they have to keep paying the interest. So overall, the sovereign debt increases. Now the sovereign debt can be cancelled off by the climate debt, because the sovereign debt is held by the non-Annex 1 countries and the climate debt is held by the Annex 1 countries. Okay, so what they're asking now is a quid pro quo, not the arrangement that we have in the Paris Agreement, whereby they say, right, you know, for the adaptation fund, we will give, you know, yearly 100 billion, which is what that video showed with that picture of the peas, saying 100 Ps, but they only gave 80 Ps, but then really they only gave 20 Ps, right? So that's the current arrangement we have for climate finance. But activists are saying, well, why don't we actually look at it this way, that you cancel all the sovereign debt that are directly related to climate change action. Okay, so that's, don't know how far that'll go, but definitely a lot of the climate activists, environmental activists, Global South activists, a lot of young activists as well are supporting this concept of climate debt. There's other interesting concepts in climate finance as well that are relevant to the discussion. So, but that's more within the system of, you know, the current economic system that we have. What do we usually do if there's a disaster? Or what do you do from an economic or financial point of view to address a disaster or to plan for a disaster? I'm asking you the question.
Insurance and risk plan.
Yeah, precisely. Insurance and risk planning, right? So you take out an insurance. There's another.
Insure yourself, like Joseph did in the Bible. Like, how was his name? He was preparing for 7 poor years, so he prepared his supply stores. That's
stockpiling. Yeah, stockpiling definitely in terms of, I suppose, expecting the event, but I suppose you'll do that alongside doing your insurance as well, isn't it? So in terms of addressing climate change, right? Now, let's say that your house is in a flood prone area. Will you be able to get an insurance?
No, Professor. It is an act of God.
That is only if you claim insurance. But even to actually get an insurance, okay, let's say that an insurance company is considering it. They'll ask you for high premiums, right? Then they will increase or they'll probably decrease the trigger points. Yeah. So you will be at a huge disadvantage to be able to get that insurance because you're paying high premium and you might not be able to claim except for, you know, extreme situations. You might still incur lots of loss, but you might not be able to claim on your insurance, which is usually the case even for other insurances, right? So that's an issue. And worst case, yes, like you said, Pankaj, you just be uninsurable. Yeah. So there is that whole category of uninsurables, which is now increasing because of climate change. Yeah. It's not just individual houses, you have whole towns, you have whole cities now becoming uninsurable. So what does that say about our main economic system? Right? If the economic system of insurance is the way in which we plan to protect our property, then by having a large increase of uninsurables, we need to start thinking about what to do. Well, some high risk investors have already thought, because there's something called disaster capitalism, right? Which means you make money out of disasters. You might have heard of war capitalism. So you make money by selling the weapon. So there's, you know, an opportunity in the war. So you have disaster capitalism as well. What is interesting about disaster capitalism is there's a level of risk that is beyond the logic of the sort of bell curve that general insurance merchants use. So basically what they'll say is they'll, you know, look at, you know, construction sector, housing sector, and then they'll draw the bell curve of risks. What they will insure is what is there in the main part of the bell. Okay, if you think about a bell, a church bell, the main part. So anything that is on the tapering end of the right or the left is all uninsurables. Okay, but now what they do with this, you know, disaster capitalism, there's some concepts called catastrophe bonds or cat bonds. This is where it's not insurance, but it is a bond. So the city of New York, after it had its big flooding in 2012, has actually invested in a catastrophe bond. So this is a solution, if you like, for those highly uninsurables. But even within this, you need to satisfy certain criteria. And there are many people that are excluded from these bonds as well. So, I mean, this topic about climate justice, about climate finance, you've got these market approaches, but you have to also take some non-market approach, just like what you were mentioning, stockpiling. You'll have to take care of yourself. You have to fend for yourself. We are sort of getting into, you know, that mode. Anyway, so that video was quick sort of recap of some of the topics from or the themes that we did before, and some that we've done like, you know, extended on today in terms of climate justice and how we can use the legal system. Okay, so let's look at another case law then. Okay. Right. This way. Okay, let me share my screen. The second case law, as I mentioned before, is a human rights case law. For those of you who are not familiar with international human rights law and the dispute settlement mechanism within that, a quick introduction to that. The international human rights law has a number of different treaty instruments, and within these instruments, there's also a mechanism. It's not a dispute resolution mechanism, but it's a complaint mechanism, as it is called. One of the leading treaties in international human rights law is the International Covenant on Civil and Political Rights. And within that, the United Nations Human Rights Committee. So this is the mechanism where the complaints go to. And the complaints are taken to the committee in the form of what's called a communication. Okay, so there is an author of a communication, and the author communicates what complaints they have. So the reason why it's set up like this is because of the nature of international human rights law. For this, to understand this, we have to go a bit deeper into public international law, and the fact that public international law is law among states, a law of states. It doesn't actually lay out rules and responsibilities and rights for any entity other than states. But as you can see, human rights does not belong to a corporate individual or an artificial entity like a state. Yeah, so corporate as well as states, corporations as well as states are artificial entities, whereas human beings are real entities. Okay, so human beings are the ones that can have human rights. A corporation can't have human rights. A state does not have human rights. Corporation does not have obligations to fulfill human rights. States do have an obligation to fulfill human rights. Okay, so because of that context is why within international law, humans or individuals are not recognized as subjects of international law. So that's why they can't claim and argue for rights. And that also results in the system that we have for complaints in relation to international human rights. Okay, so it's not a court, but it is a complaint mechanism whereby a diminished subject of international law, which is the individual human being, can call into question the violation of their rights by a particular state or states. So that's the background for this human rights case law. So the author of this communication is an individual called Teitiosha. So Teitiosha is from Kiribati, and he brought a communication to the UN Human Rights Committee. You can find the full resolution of the complaint, which took place in 2015 under that complaint number that you find there. So as you can say, it was brought to court brought to the United Nations Human Rights Committee in 2015. Okay, let's go ahead and see what this is all about. What were the contents of this communication? So a citizen of Kiribati. Kiribati is in the Pacific Ocean, Pacific Islands, and it is one of the 3 countries in the Oceania region, which is a least developed country. Okay, so Kiribati is a least developed country. A citizen of Kiribati filed a communication with the United Nations Human Rights Committee claiming that New Zealand had violated his right to life by denying him asylum despite his assertions that climate change made Kiribati uninhabitable. So this individual lands in New Zealand, and then he seeks asylum with the New Zealand Immigration Authority. And the reason is that his right to life is being affected because his country, Kiribati, is becoming uninhabitable because of climate change. The conclusion that the committee came to, the communication was admissible, so it was within the scope. As the preliminary admissibility issues were resolved in favor of Teitiosha, but New Zealand's decision to deny him the asylum was not clearly arbitrary. It wasn't arbitrary, there wasn't any error, and there wasn't a denial of justice. Okay, as before, like in the previous case, this communication resolution was not unanimous by those who sat in judgment of this particular claim made by the citizen of Kiribati. So there was dissenting opinions mentioned as well. So we will look at the dissenting opinions and see whether the future law should develop along the dissenting opinion. And if it does, then there are chances that such citizens affected in places where they're considered to be uninhabitable can seek asylum or any other recourse that they would like. Okay, so this case really went through various forums. It did exhaust a lot of local remedies as well. So looking at the period of 2013 to 14, so this was all before it reached the international forum. So the first forum that was engaged is the Immigration and Protection Tribunal. So this individual called Ione Teitiota, a Kiribati citizen, sought asylum in New Zealand. And he asserted that the effects of climate change and the sea level rise has forced him to migrate. So this is a classic example of what a climate immigrant's claim would be. Climate migrant or climate asylum seekers claim would be. Yeah. And here you got the well-established facts of which regions in the world do get affected by sea level rise and what the impacts of that sea level rise are as well. Some of those impacts we will look at as part of the reasons why Teitiota wants to move to New Zealand. But it's way more than that. And many of the facts mentioned for Kiribati is also established through research, through recognition of that within national situations, legislations as well. So we could look at this as a classic, a typical example of climate migration cases. All right, so we've got, he goes and applies to the Immigration Protection Tribunal, and the Immigration Protection Tribunal refuses. Okay, so the claim is denied. It's on appeal. It goes up to the High Court in New Zealand. And the High Court found that impacts of climate change on Kiribati did not qualify Teitiota for refugee status because he was not subjected to persecution, which is a required condition under the 1951 United Nations Convention rules to the status of refugees. Yeah. So the standard instrument that will be applied for such cases would be the Refugee Convention. So the High Court essentially agreed, yes, sea level rise, absolutely, and it does affect Teitiota's condition. However, under what law could we allow his claim? The only law that is applicable in this situation does not give scope for recognition of this condition of impact of climate change. Because if you need to be a refugee, if you need to go from one country to another, you need to be able to establish reasons for it. And one of them is that you are being persecuted in the country where you are, and therefore you have to leave the country. There's a threat to your life, so you need to be given asylum here. But in no way is the High Court able to come to a conclusion that climate change amounts to persecution. Then he doesn't stop there. He goes on to courts of appeal, the next level of appeal court. Again, the gravity of climate change was noted, but the Refugee Convention did not appropriately address the issue. So perhaps this is a step further, saying that there needs to be a relook at the convention itself. To what extent should it take into account the situation of climate change? So you can see a slow sort of recognition through this process of appeal in terms of what questions need to be asked in the context of migration and climate change. Yeah, on the one hand, how are we to interpret broadly or narrowly the scope of persecution? On the other hand, do we need a reform in the law itself? It's not a matter of interpretation, it is a matter of amendment of the law. This went even further. In 2015, it went up to the Supreme Court of New Zealand. The Supreme Court affirmed both the lower court's decision. However, in terms of precedent setting, so we know that the highest court in the land carries a lot of weight in terms of how it delineates principles of law. So here you have an interesting line of development that the Supreme Court now opens up. So the Supreme Court did not rule out the possibility that environmental degradation resulting from climate change or other natural disasters could create a pathway into the Refugee Convention or the protected person's jurisdiction. Okay. So now the legal principles on the basis of which amendments could be done or interpretations could be had to allow such a claim of climate migration is being laid out. Yeah. It is going in the right direction, but we come back to our old theme of, is it too little, too late? However, so from the Supreme Court then, you know, tenacious individual, no doubt supported by good counsel and non-governmental support, the UN Human Rights Committee finally hears a communication. Now, over here, there is a shift in the law that is being applied, because the remit of the UN Human Rights Committee is that it sits on complaints related only to the International Covenant on Civil, Political, and Human Rights, not even on other areas of human rights law, okay, not on the other covenant on socioeconomic, cultural rights, or on the third generation of rights. It only sits for the, so you've got to identify a cause of action under the International Covenant on Civil and Political Rights. Sorry, there's a mistake. It shouldn't be social, it's civil. So Teshiota files a communication with the Human Rights Committee where he alleges that New Zealand had violated his right to life under the ICCPR. So very powerful. The right to life is a fundamental right, and it is one of the first rights mentioned in the UN Human Rights, the International Covenant on Civil and Political Rights. And it's also a right that is the scope of which is very clearly understood, you know, right to life. It's not like some other rights where there could be different interpretations of or the breadth of what it means may be contested, whereas the right to life is a very strong right or cause of action to bring a complaint under. So the Human Rights Committee then heard that the asylum seeking country, which is considering this asylum for application, is now in violation of the right to life because they decided that the individual did not have enough of a standing or enough reasons to satisfy the conditions for seeking asylum. So what was the argument? Let's look at a little bit more detail into how the right to life was being violated by New Zealand. So Teshiota argued that sea level rise in Kiribati caused by climate change has created a scarcity of habitable space. Okay, so you can imagine the sea coming in, and what would have previously been land and habitable was not there anymore. So there's a scarcity of what is habitable, resulting in violent land disputes, okay, and environmental degradation, including saltwater contamination of the freshwater supply. So now you're looking at the aspect of threat to life because of violence caused by land disputes, and also threat to life because drinking water, yeah, is not available. So the argument about threats to life or the fear for their life is very quite clearly established. In terms of looking at how the panel itself looked at it, looked at these arguments, as far as admissibility is concerned, You know, as we know, in every case, you have to establish that that particular panel has the remit and the case is admissible for them to look at it. There were no issues with the admissibility. So the committee ruled that the communication was admissible because Teixeira had sufficiently substantiated the claim, and that when he was removed to Kiribati, he faced an imminent risk of being arbitrarily deprived of his life due to the effects of sea level rise. So that in itself is quite an innovation in how the link has been made. The fact that there's a risk for his life because of the sea level rise. So it might not sound innovative from the perspective of, you know, outside courts, but if you look at, you know, what has been considered as imminent risks for life, this is a novel reason that has come up before the UN Human Rights Committee. So admissibility over. What about the merits? Has his right to life been violated by New Zealand? Now, the reasons for which the court can hold that a state's action under the ICCPR is wrong are the grooves in which the committee needs to decide. Okay, so according to the committee, can only reverse a state's determination, because the state is a sovereign state, and who comes within its territory and doesn't get admitted into the territory is a decision that needs to be taken by the state, right? So the state's party's determination, it can only be reversed if it was shown to be clearly arbitrary or amounted to a manifest error or denial of justice. So there's very specific conditions within which the International Committee can intervene in a state's decision. The committee reasoned that the risk of an arbitrary deprivation of life must be personal. This is where it gets quite interesting. Yeah. So the risk of an arbitrary deprivation of life must be personal rather than rooted in the general conditions of the receiving state, except in the most extreme cases. Okay, so these three phrases over here are essential for analysis from the perspective of how climate migration should be viewed. So the risk of arbitrary deprivation of life must be personal. Yeah. So it must be, that threat must be directed personally at this individual. Is climate change personally directed to any of us? Yeah. Or is it being personally directed to him? No. So it shouldn't be rooted in the general conditions of the receiving state, except in the most extreme cases. So now the question is this an extreme case? Yeah. Now, a lot of this was considered, but let's look at what they had in front of them. They looked at environmental degradation. So we talk about climate change, and because of climate change induced changes. But how do we characterize what actually happens? Because it is environmental degradation that happens, right? So they did recognize that both environmental degradation and climate change constitute serious threats for the present and future generations to enjoy right to life. So this now provides some context about the other types of cases or other cases that are being dealt with by the committee. There are quite a few human rights cases, not just in the ICCPR, but also in national courts using national human rights legislation or using national constitutional rights, as well as at the European Court of Human Rights or the Inter-American Human Rights Courts. There's quite a bit of human rights cases that have been decided before this and are continuously being decided as well. So that gives the context of where the committee is talking about present and future generations' right to enjoy life. However, it held that New Zealand's determination that Tetiota had not provided evidence that he faced any real chance of being harmed in a land dispute, would be unable to grow food or access potable water, or otherwise face life-threatening condition. So now you're coming to his own individual position. So if you say that you're being threatened because sea level is rising, your land is being lost, and therefore there is violent land disputes, what is the real threat that you will be harmed in a land dispute? And second, you're saying that, because his livelihood was to do agriculture, so he's unable to grow food, and he's also saying that because of the salinity of the water and the contamination of the fresh water with the seawater, not able to access potable water. Okay, so the court, the committee has not been convinced that these the right to life is being threatened, is not imminent enough. Okay, so if you are in direct harm from the dispute, if you're not actually able to grow or not able to access potable water. Right, so what the committee did find, however, given the risk of an entire country becoming submerged underwater, is such an extreme risk, so the recognized extreme risk. The conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. So again, very interesting strands being teased out, even though the committee, essentially did not find New Zealand in violation of its duty to the asylum seeker as far as right to life is concerned. It lays the foundations for, where the future is going. Or, you have to keep trying with the climate litigation to see how you might be able to strengthen some arguments that are being presented here. So what has this decision opened up? The incompatibility of climate change risk with the right to life is not just the imminent threat to right to life, but it's about the right to life with dignity. Okay, so now you've got this whole idea of dignity, which seems to be a bit lesser than the actual right to life, but it seems to be an integral part of the right to life. Okay, now, considering human dignity as part of right to life is not a new jurisprudential development. It's been considered in many other contexts. For example, in abortion laws, in medical bioethical research, looking at whether an embryo can be researched. Does embryo have a right to dignity even though it doesn't have a right to life? Or an unborn child. So there's lots of areas where, the scope of right to life. And that's a whole big discussion to be had to see whether this concept of right to life with dignity is the same or could be the same as in previous contexts where the dignity has been considered to be a part of right to life, and the violation of dignity is also then amounting to a right to life. But that's an argument to be made. So the next part over here that is interesting is the risk to be realized. So there is the risk and then there's the realization. Even though it's a matter of time before the risk is realized, there's a difference between the risk and the realization of the risk. And over here, they're talking about the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. Yeah. So when the risk is realized, the right to life is extinguished. But when the risk is before the risk is realized, the right to life with dignity is extinguished. So it's a very interesting line of thought being developed in this particular case. Accepting Teshiota's claim that sea level rise is likely to render Kiribati uninhabitable, the committee explained that given the 10-15-year time frame, there was sufficient time for intervening acts by the government of Kiribati to protect its citizens. Okay, so now this question might be decided in a different way, perhaps, if it came to the committee 10 years' time. Yeah, because what they're saying now is there is still some time left before the right to life is going to be affected. What is affected now is the right to life with dignity. But with that, we agree that it is more than what generally is the case if climate change wasn't there. However, it's not enough for us to find that Article 6 of the ICCPR has been violated. 2 committee members dissented. Yeah, both of them attacked the majority's reliance on some of the factual matters. So one of them, Teiciota's family lacked potable water. So this dissenting member of the committee said portable does not equate to safe drinking water. Yeah, they may have access to potable water